All right, good morning, everyone. Welcome. Welcome to Minors Counsel training. As a commissioner in Riverside County, I really appreciate everyone being here today. I didn't realize when I was in private practice and even serving in the role as Minors Counsel how vital Minors Counsel is to the court and what a service you all provide to the court and to the children of our community. And so I just want to thank you for being here. I know it is a thankless job. Many of us in this room have had that thankless job. Oftentimes, when you're private practice, only one side dislikes you, but sometimes in Minors Counsel, both sides dislike you. And so it definitely is a labor of love, and I do appreciate everyone being here. So my portion of today is to go over somewhat the dry material, the code sections, and the case law that you know backwards and forwards. We do it every year. It's hard to make it interactive, but please let me know if you have any questions, comments, or want to share personal stories. Part of the continuing education is for counsel to meet with other Minors Counsel to go over what they do, best practices, and what they've experienced, and have that outside the classroom training. And so absolutely rely on each other, go over your past experiences and understanding of the law, because that does help out everyone tremendously. So what I tried to do is provide materials for everyone as far as the relevant code sections and case law. Luckily, it hasn't changed too much. And even as a bench officer, every time I consider appointing Minors Counsel, I go over these code sections, because you can see possibly the family code section is somewhat bare bones, and then the California rules of court really flesh out what the court needs to do, what Minors Counsel needs to do. And so I would always cross-reference those two things. And so just like the restraining orders after hearing, I will have to read to you the code section so you are aware as to what the law is. Some of it is very detailed, and so I will give a synopsis of what those are, mostly the California rules of court, what those California rules of court entail. And so I do have a PowerPoint presentation, but again, I have provided the code sections that we will go over in detail. And so we'll start with the very first code section. And so the very first code section in our packet is the Family Code 7861. And when I printed this up, I was pleasantly surprised how brief this code section was. And so what this code section entails is the court shall consider whether the interests of the child require the appointment of counsel. And so when I read that very first sentence, as many family law practitioners might have jumped on as well, is it says the interests of the child and not the best interests of the child. So I thought that was something to be aware of. And when I was trying to determine why it would say interest versus best interest, I came to my own understanding of the role of Minors Counsel as it's somewhat of a dual role, and that is you need to present to the court the best interest of the child, and also what the child, if they're requesting their voice to be heard, what the child is asking for. And sometimes what the child is asking for is not in their best interest. And so that's why I think they had chosen the word interest versus best interest in this code section. And so that is a dual role. And if the child does ask to have their wishes heard by the court, either by way of testimony or their desires as far as what custody and visitation need to be, you do need to present that to the court, even if you totally disagree with it. And you have to let the court know this is what I feel is in their best interest and this is what the child wants. And in a handful of cases, I've had that presented, and typically the court rules on what's the best interest of the child. Furthermore, Family Code Section 7861 says, if the court finds that the interests of the child require representation by counsel, the court shall appoint counsel to represent the child, whether or not the child is able to afford counsel. The child shall not be present in court unless the child so requests or the court so orders. And so, as many of you know, even if the parents cannot afford the services of Minors Counsel. There was a point in time where the county would pay for those services. That is always in flux and not guaranteed. And so the court has the ability to determine what a reasonable amount of those services are as they are appointed by the court. And the court does have control in how that payment plan is reached, if there's an amount that is appropriate and reasonable, and how those funds would be paid. The second Family Code section is Family Code 3150. And 3150A says, if the court determines that it would be in the best interest of the minor child, the court may appoint private counsel to represent the interests of the child in a custody or visitation proceeding, provided that the court and counsel comply with the requirements set forth in Rules 5.240, 5.241, and 5.242 of the California Rules of Court. So now you can see we've changed the terminology from the interests of the child to the best interest of the child. And so what the court basically needs to make a finding of always is what's in the best interest of the child. And so I think that's why this code section specifically says the best interest, because that is the determination that the court needs to make a finding of that before making any orders. And then upon entering an appearance on behalf of a child pursuant to this chapter, counsel shall continue to represent that child unless relieved by the court upon the substitution of other counsel or by a court or for cause. And so I was minors counsel when I was private practice, and I had approximately 20 minors counsel cases, and they were young children, and that could go on until the children turned 18. And then when I became the family law facilitator and I could no longer have clients, it was much more work because I hadn't asked to be relieved after the completion of a hearing or a case. And then I had to file a notice of motion to be relieved. And so just a practice pointer, if you feel that you have done your role, your duty as minors counsel at the end of that hearing, I would just ask to be relieved so you don't have to file a notice of motion. You always can be reappointed. And so it doesn't mean that you're abandoning your client, but essentially if circumstances change, you go to work for the government or become a bench officer, at least that's one less notice of motion to be relieved that you have to file. And then as you can see, we've also attached the California Rules of Court. And so the California Rules of Court really flesh out, it is very detailed what the court needs to do, what minors counsel needs to do. And it is incredibly helpful because, as you can see, the other two code sections are 2 to 3 sentences in length. And so this gives you a little bit more guidance and some boundaries as far as what you need to do. And so 5.240, appointment of counsel to represent a child in family law proceedings. We start with appointment considerations. And considering appointing counsel under Family Code 3150, the court shall take into account the following factors, including 1, the issues of child custody and visitation are highly contested or protracted. Many family law cases are highly contested or protracted, and so don't just stop at that analysis. The court would benefit from appointing minors counsel on every single high conflict case that we have. Unfortunately, we have very limited minors counsel, and really the court just needs to know what can minors counsel do to assist the court in providing information we don't already have. And so Section 2, the child is subjected to stress as a result of the dispute that might be alleviated by the intervention of counsel representing the child. Again, most every family law case that's being contested, the child is under some degree of stress. So keep moving on through your factors. 3, counsel representing the child would be likely to provide the court with relevant information not otherwise readily available or likely to be presented. And so the court, I think, starts looking at number 3. And I had a bench officer in San Bernardino County when I was in private practice, Commissioner Malum. And at that point in time, almost every private practice attorney was asking for a 7:30 evaluation. Maybe we had more evaluators, maybe it wasn't as expensive, maybe it was somewhat of an easy way out because mediation is limited to 45 minutes to an hour to get to the heart of the issue. But Commissioner Malum was very selective in appointing 7:30 evaluations because he would always say, what is that evaluation going to tell me that I already don't know? Both counsel have done an excellent job representing their clients. I know both positions. I know what impact it has on the child. So what is this extra $10,000 to $30,000 evaluation going to present to me? And so then we had to think about that. You know, you're right. There's not much more that we can say. We're just kind of beating this dead horse. And so then that responsibility became placed upon the bench officer to make a decision. So that's always something to be mindful of as well. And then number 4, the dispute involves allegations of physical, emotional, or sexual abuse or neglect of the child. When I was a commissioner in San Bernardino, the cases that I typically saw involved domestic violence of the parents. And so that was the biggest issue that I saw. And so that obviously, if the child was privy to that, if they had seen it, that was something the court needed to consider very, very closely. And usually a restraining order was in place, which gave the court a little bit more guidance as far as what the orders were. In Riverside County, since I've been here, what I've seen more frequently, and again, it's only been approximately 4 months on the bench in Riverside, but what I've seen is a lot of sexual abuse cases, and what I've seen is a lot of sexual abuse allegations of children that are typically 4 years old, really unable to communicate. We usually have Family Code 3027B reports done, usually because the child is unable to communicate a lot of information or just doesn't feel comfortable speaking to an outsider. The court doesn't really have a lot of additional information other than it's unfounded. And so, but there's always in the back of a bench officer's mind is what if the allegations are true? And so minors counsel can stick through the case to give the court a little bit more insight as far as what is going on day to day, week to week. And so for me at this point, I feel that the sexual abuse allegations are more frequent and definitely something that the court doesn't want to make the wrong ruling on because it can have a significant impact on that child. And then number 5, it appears that one or both parents are incapable of providing a stable, safe, and secure environment. And so for me, before I appoint minors counsel, honestly, I need to find that both parents are incapable of providing that environment. Because if I have one parent that is reasonable, has followed court orders, has testified to things that are in the child's best interest and not trying to take a position to gain favor, possibly in a dissolution of marriage case, the court is going to rely on that parent or party. But if I see both parents are a problem, that's when I'm going to actively start thinking about appointing minors counsel, and then again be very selective if I do appoint minors counsel because we have such limited amounts of counsel that are willing to serve in that capacity. And then 6, counsel is available for appointment who is knowledgeable about the issues being raised regarding the child in the proceeding. I never have a concern about that, not with this bar association, not with the attorneys that we have before our court. That is never something that the court is concerned about. I know the attorneys that have spent the time training and getting themselves ready for this role. 7, the best interest of the child appears to require independent representation. Really, that's just all the factors above that we've discussed already. And then 8, if there are 2 or more children, any child would require separate counsel to avoid a conflict of interest. So I've had this happen probably just once as minors counsel, and that was San Bernardino. All my cases that I'm going to speak about today are San Bernardino County when I was in private practice. But what I see that as typically the scenario is that usually there are 2 to 3 children. One child is usually a little bit older, a teenager. The other one is smaller. The smaller child is, I don't want Sissy to go live with dad. I want Sissy to live with me, and I want to stay with mom. And so that's just kind of, just the cookie cutter example of it. And so at that point in time, now you have a conflict because the oldest child does not want to be with mom and the youngest child does not want to be with dad. And so at that point in time, you have to then remove minors counsel that was originally representing both and now try to find two other minors counsel to possibly represent both children. You don't have to. If you feel that the youngest child seems stable, secure, in a good environment, maybe you just appoint a new minors counsel for the teenager, typically, if that is the one who's struggling. What I usually see with the teenagers struggling before I appoint minors counsel, a very unfortunate and a very popular scenario is the teenager is struggling in school, the teenager is cutting themselves, the teenager has suicidal ideations, and has very strong opinions. And both parents come in saying, we've tried everything we can do, and sometimes there's an allegation of sexual abuse or physical abuse. And so at that point in time, I feel that would be appropriate to have that teenager appointed minors counsel. And sometimes, honestly, it's just the stress of possibly being involved in the family law system for that teenager's whole life, where the other child is kind of the tail end of the family law proceedings. And then a request for appointment of counsel. This one is essentially just about anyone can ask to have minors counsel appointed. And so the court may appoint counsel to represent the best interest of a child in a family law proceeding on the court's own motion, or if requested by a party, the attorney for a party, the child or any relative of the child, a mediator, a professional, typically that's one of the 730 evaluators or 3111 or 3118 evaluator, county counsel, district attorney, court-appointed guardian ad litem or special advocate, and then 8, your catch-all. Any other person who the court deems appropriate. So essentially anyone can walk in and based upon standing can request minors counsel. And then C, orders appointing counsel for a child. The court must issue written orders when appointing and terminating counsel for a child. And it's very bare bones what the court has to do. And just as a practice pointer for the court, I try to get those orders done the same day. Because we do have congested calendars, and honestly, by the very next day, what was handled yesterday seems like that was a month ago, and so we try to get it done the very same day just to make sure we don't miss that order being sent out. I was also advising Judge Wells that at least in my courtroom, what I do is set it for confirmation of appointment of minors counsel, and that way they can do their conflicts check. Although I do ask the litigants if they have a conflict with who I'm suggesting as an appointment, oftentimes they don't remember, or they're scared, or they misunderstood the question. So I make sure that we do set it for confirmation. And should that not work for you, that's absolutely fine with the court. I understand everyone in this room has very busy calendars. I understand you're not likely to get paid, and if you do, it's not going to be much. And it really is a service to the court, and so we just appreciate what you can do. But as far as the orders, what orders have to be included, as I said, it is very bare bones. The appointment orders must specify appointed counsel's name, address, and phone number, and then the name of the child for whom counsel is appointed. And then on the date of birth. And then what Section 2 says is the appointment orders may include the following. And based on my years of this class and training and learning from other bench officers what is essential, the court, even though it says may, this court at least tries to include all of these things. The child's address, if appropriate, issues to be addressed in the case. And the one thing I learned with mediation and minors counsel is even though I might know what I'm looking for, absolutely every single case that comes into their office, they have no clue. It's starting from scratch. And so if I'm really just asking for, is this child being alienated by one of the parents? Has this child witnessed domestic violence? Is there any inappropriate touching? And just really lay it out for Minors Counsel to jump into that issue. Tasks related to the case that would benefit from the services of counsel for the child, responsibilities and rights of the child's counsel, that actually is already included in our order. So I don't have to repeat what the responsibility and rights are of child's counsel. And the thing I like about the order most is when I was Minors Counsel, and I would go to schools, and it would be a foreign thing in certain communities. What is a minor's counsel? And this is a minor child, and you're not on any of the cards that say we can talk to you. As long as I presented a certified copy of the minor's counsel order, it listed everything I was entitled to, and they readily complied. And so it avoids any confrontation, argument, delay. And so that's absolutely helpful if you decide to visit with the child at the school to bring that with you. Counsel's rate or amount of compensation. So when I appoint minors counsel, the judicial assistant, the courtroom assistant, magically seems to know what minors counsel's rates are. And so when you do sign up on the list for Riverside County, if you can also include your rate, that is incredibly helpful for me then to tell the parties, I'm appointing minors counsel. I'm going to have you equally split the cost of minors counsel subject to reallocation. You're going to have to file income and expense declarations. And luckily for you, minors counsel rate is $200 an hour. And so then they can relax a little bit knowing that it's not going to be the $500 that they had to provide recently. Yes?
I just want to say, if you can note for the county, if you could include the parent's phone number or contact information. Sometimes we get appointed and we have no information about how to contact anybody.
Oh.
And another thing might be an order that the parent has to contact minors counsel within
a certain amount of time.
Or whatever.
So if you can't reach out to them, they should be reaching out to you. Okay, that's very good. Any other suggestions regarding the orders and appointments? Feel free. This is definitely interactive, so interrupt me at any point in time.
And I'd just like to say,
yes.
Years ago I had a situation where one of the parents was unhappy with my recommendation, and I believe it was Commissioner McCoy at the time, and he chose not to pay my fees, and so Commissioner McCoy said, I will relieve you, Ms. Williams, and I said, don't think so, and so I don't charge. I do that. I'm semi-retired.
Right.
And I do that because I don't want there to be a question of, my fees and whether or not I have an interest in one party or the other, and both parties feel like they get full,
Absolutely, and that is a real thing too, because
so don't hesitate. Don't take a bunch of cases.
Right.
I love the minors counsel cases, and I like
absolutely.
The hard ones, and
right.
I'll do those for free.
Absolutely, and so I think if when you do sign up on the minors counsel list. And when I see that someone is doing it pro bono for free, typically I will save those. I typically don't want to abuse those for something that I could figure out, or it's going to take maybe a couple more hearings before I can figure out. But there's certainly cases that I absolutely know I can't do this on my own without boots on the ground, so to speak. And so I do appreciate that. And when I was minors counsel, not saying that anybody has to do this, but for me, the collections and the paperwork to try to get paid, typically I spent more time trying to get the money. Typically I spent more time trying to collect the money and sending in forms to the county. And so I would do those pro bono, but like Sheila, limited, because essentially it was just a service to the community, my pro bono hours that I should be doing anyway. And then as far as terms and amount of any progress or installment payments, and so this is where the income and expense declarations come in. And so most people know, on the court's own motion, if I'm going to appoint minors counsel, usually we don't have income and expense declarations. Maybe lucky we do, but if we don't, then I order those to be filed. and then I'm looking at what their income is, what their expenses are, what their assets are, and then trying to figure out what can they pay each month to at least in good faith pay minors counsel on a regular basis. And so that's very important to me, to make sure that the people I ask to help me get paid. And I do agree with Sheila that typically can be an issue that's raised. Well, the other party paid for minors counsel, so minors counsel is going to, advocate for the other party. And I hear that all day long. I don't really consider that as a factor. I know counsel would not put their reputation and their career on the line for one case where maybe they were paid $1,000. So that's not a consideration unless there's some absolute bad faith actions that have taken place. And then the ability of the court to reserve jurisdiction to retroactivity to modify the order on fees and payments. That's always a possibility for the court. The most important thing, panel of counsel eligible for appointment. Each court may create and maintain a list or panel of counsel meeting the minimum qualifications of this rule for appointment. So in San Bernardino, we didn't have a list. And I see that that is a may, not a shall, create a panel. And so now I understand why we didn't have a list. Because if you do have a list, you have to regularly make sure everyone on the list has met the criteria for education, continuing education, has submitted their paperwork, has insurance, liability insurance, or can cover the costs if they are being sued. And so I was very tempted to bring a sign-up sheet today and have everybody sign in to be a part of the list, but I thought that might be undue influence. And so what I'm just going to... I know. I haven't been here that long to be able to do it.
There is somebody at Riverside. There's a clerk in Riverside.
I think Carrie Gates.
She
yes.
sends out the requests, I think it is March or April.
Okay.
When those go out for the eligibility requirements.
Right.
And,
And I did reach out to her, letting her know my secret intentions. So her name is Carrie Gates, if you don't mind reaching out to her. Again, I think we have one on the list locally. And so it has been a real struggle. I was even trying to recruit people at Enza Court last night who said that they only do Riverside. And so if you can reach out. And then as far as the list, you can see everything that is required. Complaint procedures. So we do have a local rule regarding the complaint procedures, and so you can check our local rules as to how that officially needs to go forward. As minors counsel, I had one request for order filed to remove me as minors counsel, and very similarly as Sheila, they didn't like the declarations I was presenting. They didn't like what I was looking into. They thought I needed to do something outside the scope that entailed more investigative work that had nothing to do with the custody and visitation. And so they did file a request for order, and I told the bench officer, I completely understand whatever you feel is appropriate. So sometimes it's just easier to start fresh. Other times they value what efforts you've put in. Sometimes I've asked to be relieved and that has been denied. That again was a different county. Only because the cases that I asked to be relieved on, they thought that information was valuable to the bench officer because of the reasons why I was asking to be relieved. Either it was a threat to my safety, either it was the child lying to me, and I now had a conflict with my client because there were multiple lies that we were having to go back and forth on. And that bench officer said, no, that's exactly the information I need to hear. And so sometimes you will be denied that request as well. And then again, termination of appointment, as I had stated, that can be until the child turns 18 or you ask to be relieved after the end of your hearing subject to future appointment, or if the court decides to substitute you out for another counsel. So that's always important to be aware of. And then we'll go on to the California Rules of Court. I'm just looking at our time. I have approximately 20 minutes, so I'll try to speed this up. Compensation. Oh, thank you. No, that's okay. I appreciate that. Thank you. I need a lot of help here.
We all do.
I've got a lot of papers in front of me, so thank you. And so, California Rules of Court 5.241, compensation of counsel appointed to represent a child in a family law proceeding. This is pretty straightforward. I think you all can read this on your own, and it's absolutely in your best interest to read how you would get paid. But it's very, very similar to what I've already reiterated, is the court at that first hearing can make an initial preliminary temporary order that you equally pay, have them file income and expense declarations. At the next hearing, the court decides how to divide it up. And the court has to decide what a reasonable amount is, and so that is not something I've had an issue with. All minors counsel have presented very reasonable expenses to the court. And then a timeline. So the only timeline I would be aware of is the court should determine the party's ability to pay within 30 days after appointment or at a subsequent hearing. And so that 30 days is important because sometimes our hearing dates get pushed out so far. And so the court does try to make sure that we set it within that 30 days to make sure counsel knows how they're going to be paid and what amount they're going to be paid. And so I'll let you read that a little bit more carefully. And then the qualification, rights, and responsibilities of counsel appointed to represent child and family law proceedings. This is on the order itself. Let me just click to that. Thank you, Sheila. And the purpose is for the rules govern counsel appointed to represent the best interest of the child in a custody or visitation proceeding under Family Code 3150. So as we started, you can see Family Code 3150 is 4 sentences long. So some people just rely appointed by pursuant to Family Code 3150, and that's where they stop. But if you go to the California Rules of Court, you'll see this is 5 pages of what Family Code 3150 means. And so I, again, think that's a blessing because sometimes you feel like you're working in the dark as to what is required of you. And so the general appointment requirements to be eligible for appointment as counsel for a child, counsel must be an active member in good standing of the State Bar of California. And then number two gets overlooked often, have professional liability insurance or demonstrate to the court that he or she is adequately self-insured. And so what I'm hoping is that when you are all signing up for the panel with Riverside County, that they're inquiring of this, because I don't inquire of this at all. And so if that's not the case, please let me know, or please let Carrie Gates know that is being met by everyone signing up for the panel, because I don't feel that necessarily the court should be placing that on the record. I can if they're not checking that, but I certainly want to make sure that those qualifications to get on the panel is being addressed outside of the scope of being on the record or in front of other parties. Exactly right. So if they can do it pursuant to how to get on the panel, I would prefer that. And then meet the education, training, and experience requirement of this rule. And so the rule, I believe, and anyone can correct me, if it's your first time training as minors counsel, then you have 12 hours for that first year, and then you have to consecutively attend minors counsel training, and that's 8 hours every year. If you miss 1 year, you start all over with the 12 hours. That's correct? Okay, that's what I thought too. And then the education and training requirements, that should be everything that is done today. And I can tell you my favorites in this training have always been ages and stages. And for a while it was hotly contested, the ages and stages, with certain bench officers. And so I always found that the most interesting as far as just the development of the child, and when they can bond with one parent, when they can bond with 2 parents, how long they can be away from those primary parents. And it was never a mother and father issue. It was always who was the child bonded to immediately, and then when were they able to have an attachment to 2 parents. You're placing a lot of responsibility on a baby who's 3 or 4 months old to then be able to do all these multitasking and have that connection to multiple people at the same time. And so I try to always advise my parents, this has nothing to do with gender. It has nothing to do with love. It's mostly biology. And they take it, but, you know, I get it. You feel like at some point you should have the same amount of rights and responsibilities, but I have to remind them it's all about what the baby can consume until they're old enough to be able to appreciate the relationship. And then as far as the other class that I really, really enjoyed, it was always the cultural and ethnic diversity. And so for me, it was just always important to know what everybody in their culture, their history finds to be important to their family values. And so it's not just what I think is important to their family, but what generations have established before the court got involved. And then we have already gone over the annual education and training requirements, but I did highlight for my own notes applicable education and training section 1A, a professional continuing education group. And so that's why I think it's so important to reach out to one another and to express, hey, I have this case. Have you ever seen anything like it? And then just share these stories and experiences. And hopefully that gives you some sense of, I know when I was at judicial college, and the courts have a lot of discretion. And so we would go through, let's say, the 4320 factors, and one bench officer would do this, and the other bench officer would do something totally different. And so what the training taught us is, as long as you're in the realm of what is good discretion, you're fine. It's when you're out here doing something totally inappropriate that you're in trouble. And so I think that's what these educational groups are. Do what you think is right. Make sure you're in the realm of what is reasonable. And then we'll go on to, I'll let you read the other requirements because that, and the responsibilities. I'll go over the responsibilities though. 10 minutes, okay, we got this. So the responsibilities are to interview the child, review the court files, and make any further investigations that counsel considers necessary to ascertain the facts relevant to custody or visitation hearings. What's really important to remember is you are an attorney. You're not a social worker, you're not a mediator, you're not an evaluator. And so what you would do for the petitioner, what you would do for the respondent, you're going to do for the child. So nothing different. The only thing different is probably the attorney-client privilege, because you do have to let the minor child know that there's limitations in the confidentiality because you're sharing this information for the best interest of the minor child. But you cannot be called as a witness. You have the rights to everything filed in the case. You have the right to be served with everything regarding the child. Sometimes people think that just means custody and visitation. That can also mean child support. And so I had what Minors Counsel recently say, well, I would like to be a part of the child support hearing because that affects my client as far as what the support order is. Even if they're silent, they just wanted to be present in case anything was a red flag to them. So all of the things that affect the child, you have a right to be there. Yes?
I just want to, real quickly, I had a case one time in Placerville, Sacramento,
Mm-hmm.
out there. And I told this group before that up there, Minors Counsel is involved in every child support hearing. In fact, they frequently, the attorney brings the child support request. So every county is different.
Every county is different, and that is so true. Absolutely. And then also you have the right to bring your own motions, your ex partes, your discovery, all of those things that you would do as an attorney as well within your right to do so. I also included what the child's desires are. So you, as Minors Counsel, really are not supposed to say, where do you want to live? Who do you want to live with? You're really not supposed to do that. The child is supposed to give you enough information for you to put in your declaration what you think is in the best interest of the child. Not even really a recommendation, but again, as what you would do as a petitioner or respondent's attorney. These are the orders we're requesting. And so sometimes a child will freely offer that information. And so you do want to make sure that they want to share their desires or wishes as to which home they want to be in, but that's not something that you should ask point blank. Absolutely.
So back to the recommendation.
Oh, no, absolutely.
So you want us to make recommendations, or?
I would prefer they not show up as recommendations.
Well, the reason I said that is Mom has a position, Dad's has a position. He's going to say what he wants.
Right.
The outcome. The
Right.
Mom's going to say that. So we, as minors counsel, in that same situation, rather than using the word recommendations and the best interest of our client.
Right.
I can't think of it.
Exactly.
This is what I advocate.
Right.
Yeah.
It's semantics.
It's advocating the best interest of my child.
There
Yeah.
was a recent case that came out on this, I think to clarify that it is allowed, you are allowed to make recommendations to the court. It's a 2023 case.
Yeah, you can do so, but not under the guise of being like a social worker, mediator, evaluator. So I recommend to the court that this is in my client's best interest. So it's, again, just like slight wording.
I think more interesting.
Advocate is much.
Yeah,
Cleaner.
clear.
And what about Sanchez in these
Oh,
regards?
yes. That's a big,
much more difficult question.
absolutely. And I would love to just have a training just on Sanchez, especially in custody and visitation cases. And then I'm just seeing quickly, 3152, Family Code 3152. This one is overlooked a lot as well. And so this states the child's counsel may, excuse me, upon notice motion to all parties and the local Child Protective Service agency, request the court to authorize release of relevant reports or files concerning the child represented by counsel or the relevant local Child Protective Service agency. The court shall review the reports or files in camera in order to determine whether they are relevant to the pending action and whether or not, to what extent they should be released to the child's counsel. Neither the review by the court nor the release to counsel shall constitute a waiver of the confidentiality of the reports and files. Counsel shall not disclose the contents or the existence of the reports or files to anyone unless permitted by law. I think we've somewhat addressed this by a Family Code 3027B investigations. I think that is a way that information does come in. It's still confidential. I still have to have the parties sign that they will not share this information and release this information to the parties. But I don't see, unless the other counsel have seen it, I don't really see these requests for orders being filed, but more so the 3027B, a history of the case. And so that has been somewhat easier. Yes, Ms. Adams.
We do have two new judicial officers,
Mhm.
and what we've gotten to do in the past, I would say year or two, is while in court or filing an RFO, asking that 3027
Mhm.
report can be shared with a therapist who might be involved,
Right.
or the child, or 730 evaluator, something like that. So you have to have permission even for a 730 evaluator or a therapist in the case.
Exactly right. Exactly right. Mhm. Sure.
Pretty quick, but
Yes.
from the mental health
Mhm.
perspective, Lydia, you said it earlier, like, to release so that you write orders saying what you need. I cannot tell you as therapists how important that is to us, because we get these people coming in, they're all in litigation.
Right, right.
And we don't know what it is you want.
Right.
And if we listen to the parents,
Yeah.
it's, you know.
Right, right.
Right, so we really need that from you
Mhm,
guys.
mhm.
Yeah, that
Sure.
tells us what it is you're looking for.
Absolutely. And I know even with mediation, and so the hardest part, I think, of the job is just the caseload and the time that you have. And so I try to make sure that I put in there just what the allegations are. But I know even with mediation, we're starting to do that as well when we want the child to be interviewed. Because otherwise they have, a 10-year-old come in and they're like, so how is your day? So what's going on at home? Fine, like you would do with any stranger. And so if we can say, like, this is what the child is saying, then they can have more pointed conversations with the child, which is helpful. So I do appreciate that, and we definitely try to make sure we at least give you bullet points. Did you have a question?
I did.
Uh-huh.
I'm Carol.
Yes,
Hi,
nice to see you.
Kind of to piggyback off of what Diana said, one of the things that I get, probably you do too, Diana, is parents come in and say, well, I need you to write a letter to the court.
Yes.
And that is that ongoing issue, and my position and what I've learned.
Right.
We don't write a letter unless we are, it's put
Right.
in that we're a reporting therapist.
Right.
And even if both parents want it, and a lot of times,
Uh-huh.
whoever's on the bench that wants it to be confidential with the child.
Right, right.
So there's sometimes a little bit of dilemma. I take the position that, no, I can't do that unless the court asks
I
me to.
totally agree with
Is
that.
that
I
correct?
totally agree with that. And in fact, I have attorneys come in arguing all the time. Ms. Bear wants to report to the court. Yeah. And I want to say, and I have said, here's the only problem is when we have a mediator, right? We have a 3027B investigator, and we have someone the child trusts with the most personal information for the child to heal. And so the minute that one person who is neutral and confidential then tells the court, well, child said this about the other parent, then the child's not going to communicate. So, and this is what I've shared. And so I totally agree with you on that. And the response back is, well, they're a mandatory reporter and they're reporting these things, and the 3027 CPS investigators don't take it seriously. So that's the whole balancing act. It's always a balance. And so for me, I understand CPS sees the worst of the worst. So I understand what they think, hey, this is just a family law issue, is still very important to family law. But at the same time, you kind of know the parties after a while, and the issues that are raising can easily be addressed just by the bench officer. I don't need that child to think they have no one to talk to now.
And in many cases, there isn't a CPS report. Maybe
Right.
it's just the child's not happy, or,
Right.
or they're not being fed well, or they're not bathing them, but they're showering them. So, yeah, it's the same thing.
Same
So
thing.
ridiculous things that we don't
Exactly.
do, of course.
Exactly.
Oh,
Okay. Everyone's like, it's time out.
Well,
One thing I'd like to say real
Sure.
quick about 3027 reports.
Uh-huh.
It's exactly what you've raised. What I'm noticing is they are like referring a child for counseling at Barbara Sinatra, but they're saying this is inconclusive or this is
Right.
unfounded because it doesn't rise to a legal reason to bring it into juvenile court. That's
Exactly
what I'm
right.
reading.
Right.
Even though they're also telling you, hey,
Mhm.
we're sending this child out for therapy. And that's changed a little bit in my point of view. I mean, from what I'm seeing in the last few years, they're doing a lot of things that doesn't rise to the legal.
Exactly.
um,
It's just a
court.
very different standard. It's different courts. And so I think they're just saying family law can figure this out. Yes,
Okay,
Judge?
thank you.
Thank you.
Diana was sitting
Thank
back
you.
there doing this.